Hello, everyone. Thank you for joining us for today's webinar, Navigating Post-McGirt Challenges, How Tribal Courts Can Manage Increased Caseloads. We're excited to dive into a topic that has profound implications for tribal justice systems. The recent Supreme Court decisions in McGirt versus Oklahoma and Oklahoma versus Castro and Huerte have brought new challenges and opportunities for tribal courts as they define jurisdictional boundaries and increase the responsibility tribal courts hold in delivering justice. Our discussion today will explore these impacts and introduce innovative solutions to help tribal courts adapt to their growing caseloads. Before we begin, I'd like to introduce our speakers, who bring decades of experience and dedication to supporting tribal justice. Lane Dunn, the Justice Product Manager at Avenue Insights and Analytics. Lane began her career with the clerk's office at the U.S. District Court, and she's held various roles as a court administrator and jury administrator in both federal and state jurisdictions, including work with the Oklahoma Supreme Court. With more than 20 years in court technology, she has served on the national advisory committees and led the implementation of court technology solutions across the country. Lane, thank you for joining us today.
Thank you, Ellie.
And Lenny Powell, a staff attorney with the Native American Rights Fund. Lenny is an experienced litigator and advocate with a deep commitment to tribal sovereignty. Before becoming an attorney, Lenny served on the Tribal Council of the Hopeland Band of Pomo Indians. His work includes involvement in the landmark cases like McGirt versus Oklahoma, and he's been recognized as the Native American 40 Under 40 honoree in 2023. Lenny is a leading voice in tribal rights and advocacy. Lenny, thank you for being here today. Look forward to hearing from you.
Thank you, Al.
Before we begin, I want to introduce you all to Avenue Insights and Analytics. Avenue has been a trusted partner to state and local governments, including more than 25 years dedicating to providing justice solutions for federal, state, and local courts. With over 4,500 clients nationwide, Avenue designs software solutions specifically for court administrators, including jury management, to meet the needs of diverse court systems. Whether you're already familiar with Avenue or joining us for the first time, today you'll learn more about our commitment to helping courts operate more efficiently and addressing the unique needs of their communities. During today's discussion, we'll begin by examining the situation following the McGirt and Castro Huerta decisions and the unique challenges these rulings pose for tribal courts. Our speakers will discuss the specific obstacles tribal courts face in balancing expanded jurisdiction, managing increased caseloads, and implementing cost-effective technology solutions to meet these demands. We'll conclude with case studies and examples of successful strategies that have helped tribal courts address these issues. And with that, I'll hand it over to Lenny Powell to discuss the current situation and challenges facing tribal courts following the McGirt and Castro Huerta rulings. Lenny?
Thank you, Allie. So I'll start out by talking about the McGirt v. Oklahoma decision, as well as its companion case, Sharp v. Murphy. These are a pair of Supreme Court cases that the court decided in 2020, and they concerned application of the Federal Major Crimes Act. Now, that statute preempts state criminal jurisdiction over major crimes committed by Indians in Indian country. Mr. McGirt and Mr. Murphy were criminally convicted by the state of Oklahoma, but they are Indians, and they claimed that their alleged crimes occurred within the boundaries of the Muskogee Creek Reservation. So the key question was, does the Creek Reservation still exist, or did Congress disestablish it by the time of Oklahoma statehood? By a vote of 5-4, the Supreme Court held that the Creek Reservation persists. Writing for the majority, Justice Gorsuch determined that Congress never disestablished the Creek Reservation. He emphasized that, quote, on the far end of the Trail of Tears was a promise. Today, we are asked whether the land promised by treaty to the Creek Nation remains an Indian reservation for purposes of federal criminal law. Because Congress has not said otherwise, we hold the government to its word. The decision was perceived as immensely important. For nearly 115 years, the state of Oklahoma had acted as if there was no longer a Creek Reservation, so the practical changes resulting from the court's decision were expected to be significant, and that was especially so because of the Creek Reservation's size, roughly 3 million acres including most of the city of Tulsa. And making the anticipated ramifications more significant still, many predicted that McGirt's reasoning would lead to recognition of the continued existence of the other reservations that made up the Indian Territory before Oklahoma statehood, which in total cover nearly half of Oklahoma's current boundaries. Now, if we can go to the next slide, please. At least some of the predictions about McGirt's impact came to pass. In the immediate aftermath of the decision, the Oklahoma Court of Criminal Appeals, or OCCA for short, recognized the continued existence of other reservations in Oklahoma. The amount of Oklahoma land deemed Indian country quickly approached the anticipated halfway mark. Now, the recognition of these reservations has resulted in increased litigation over Indian law questions. One of the questions that most immediately came to the fore was whether federal law preempts state jurisdiction over non-major crimes committed by non-Indians against Indians within Indian country. And that's the question that the court took up in Oklahoma versus Castro Huerta. This time, the court said no, state law is not preempted. The vote was again 5-4. Justice Kavanaugh wrote for the court. He concluded that the text of the statute that confers federal jurisdiction over non-major crimes committed by non-Indians against Indians in Indian country, the General Crimes Act, does not preempt state jurisdiction by its terms. And he also deployed a test known as Brecker balancing, under which state law is preempted when relevant federal and tribal interests outweigh relevant state interests. Justice Kavanaugh determined that the Brecker scales tipped in favor of state jurisdiction. Justice Gorsuch penned the dissent. He compared Oklahoma's effort to assert this criminal jurisdiction to the court's seminal decision in Worcester v. Georgia, in which Georgia arrested a white missionary for preaching to the Cherokee on tribal lands without a license. In Worcester, the court found Georgia's prosecution preempted, and the General Crimes Act was enacted just 2 years after Worcester and against its backdrop. Given this historical context, Justice Gorsuch would have held that Oklahoma lacked jurisdiction to prosecute Mr. Castro Huerta, and that it was preempted by the General Crimes Act, but Justice Gorsuch's view did not carry the day. If we could go to the next slide, please. Now, although McGirt and Castro Huerta concerned state and federal jurisdiction, McGirt also has substantial implications for tribal jurisdiction. Tribes possess jurisdiction in Indian country in many circumstances. In fact, there are some scenarios where only the tribe is empowered to act within reservation boundaries. That occurs, for example, when an Indian commits a non-major crime against another Indian. Tribal courts are thus tasked with navigating this complex landscape of federal, state, and tribal laws. Now, this task can be challenging at times. The tribal courts often face challenges with funding, staffing, which can limit their ability to implement new technologies or expand services. And tribes have to think creatively, e.g., about how to address these issues. For instance, when I was a tribal leader and we formed a court consortium with other tribes, we sought to minimize our costs and pool staffing. And ultimately, solutions must be cost-effective, easy to implement, and require minimal maintenance in order to work this out. And with that, I think I'll hand it over to Lane.
Thank you, Lenny. I'd like to talk about how the increased case volume as a result of these cases impacted the courts and the clerk's offices where I originally started. I've brought up some statistics for 4 of the major tribes in Oklahoma, and you can see and hear representative how these cases and the caseload impacted the courts. Some of the courts increased. The U.S. District Court for the Eastern District and Northern District of Oklahoma, their case volume increased by an anticipated 25,000%. Judge Amy St. Eve from the U.S. Court of Appeals in the 7th Circuit was quoted as saying, "The impact has been nothing short of seismic." This is a large, large pool of work that is impacting the court clerk's office, both in case management perspectives and in jury management perspectives. For example, the Muskogee Nation, you'll note the last bullet point there, their criminal cases filed increased by over 4,000%. It doesn't extend just to the clerk's office, though. Think about all of the additional staffing that was required. Judges, pretrial services officers, probation officers. It also impacted court security, court technology, and courthouse infrastructure. Are there enough courtrooms to accommodate the increased caseload? So this has some far-reaching ramifications. Next slide, please. The resource allocation challenges. For those of you that have worked in the courts for a long time, you know that courts are always challenged to do more with less. So did the funding for the courts increase to manage these particular challenges? Yes and no. We don't have specific dollar amounts on how much budgetary increases were requested or granted. But considering all of the positions that I just mentioned, judges, court staff, et cetera, that rounds up to a very large increase in court budgeting. So what are some of the answers that we can implement here to assist with the caseload increase? Well, technology is one of them, and that's what we'll be talking about in this presentation. Next slide, please. As I mentioned, the U.S. District Court's caseload, they anticipated by the time the Post-McGirt cases were all settled and everything had, the dust had settled, and the cases were being moved to the U.S. District Courts, again, an increase of 25,000%. Lenny, I'll send this back to you for discussion on the intergovernmental relations.
Thanks, Lane. So one area where there has been substantial development in the wake of McGirt is in attempts to navigate this new jurisdictional landscape through cooperation between the state, federal, and tribal governments. Now, many in the wake of McGirt on the tribal side hoped that McGirt would present a new opportunity for tribal-state relations. In some ways, that has come to pass. In other ways, it has been mixed. Many local governments and tribes have entered into hundreds of cross-deputization agreements recognizing combined policing authority and even court jurisdiction at times over the Indian country lands in Oklahoma. At the statewide level, however, the reaction has been more hostile. In particular, current governor of Oklahoma, Governor Stitt, has seemed to have been no fan of the McGirt decision. He's pressed many legal challenges to tribal authority and to restrictions on state authority. And there was recently, in fact, just this cycle, there was a recall election involving 3 Oklahoma Supreme Court justices. It was perceived that at least one of the reasons their recall was sought was that they may have been believed to be too friendly to tribal interests, and one of those justices was, in fact, recalled. Many disputes remain to be litigated, so the ramifications of that could be significant. Next slide, please. So when we think about how do these decisions ultimately impact tribal governments, both in Oklahoma and elsewhere, well, they reinforce tribal sovereignty and self-government in Oklahoma in particular by recognizing the tribal boundaries and the more general principles, especially those announced in McGirt, about holding Congress to its promises, provide avenues for tribes to continue to assert their authority based on the promises that Congress has made to them in particular. Castro Huerta, however, has opened issues about the bounds of state authority, which is often perceived to be an intrusion into state authority. All of this creates, again, a complicated landscape for tribal courts who have to navigate these areas, and creates a real need for effective management, including of expanded dockets, and requires coordination with state and federal governments as all 3 work through these new rules. Again, especially in Oklahoma, though, these are things that tribal courts have to deal with all throughout the country. Next slide, please.
Thanks, Lenny and Lane, for walking us through the legal landscape and the implications of these significant rulings. Now, with this expanded role comes a range of unique challenges and needs that tribal courts must address to effectively manage their increased caseloads and jurisdictional complexities. Now, let's dive into these challenges and explore the specific needs of tribal courts.
Yes, I'd like to talk about some of the, we've already talked about some of the coordination with external agencies and intergovernmental relations. The unique needs of the tribal courts are such that we still have to provide technology to the courts to improve their business case processing. There may be language issues that need to be resolved, providing public-facing applications with language translation services or offering language in multiple dialects. Of course, training and education is always very important, but consider the impact of providing remote training as opposed to on-site go-live training. So there are a lot of ways that we can implement efficiencies for the tribal courts, particularly in the smaller jurisdictions. Lenny, I'll turn it over to you to talk about some of the other needs.
It's like another need is dealing with the complicated landscape of sovereignty and jurisdiction. As we touched on, there is a set of decisions and statutes that set forth the boundaries of the state, jurisdiction, and country. Tribal courts have to be mindful of where the limits of their jurisdiction are and apply at times quite technical legal tests in order to determine those boundaries. And in the meantime, there are constant challenges to tribal court authority. So tribal judges have to make these decisions in the shadow of potential federal court review. At the same time, there's cultural sensitivities for judges and litigants, especially when they are non-Indian, to consider when they're working in the tribal court context. Tribes have their own laws, their own histories, and their own customs. And the way things work in tribal court is not always exactly the same as how it will work in, say, state or federal court. Of course, even state courts can vary substantially from each other, and that is equally true within Indian country. There's also jurisdictional complexities that we've touched on, not just in terms of determining the tribal court's jurisdiction, but also there can be overlapping jurisdiction in Indian country. Sometimes the state and the tribe have concurrent jurisdiction, or even the state and the tribe and the federal government have concurrent jurisdiction. So working out, in practice, whose case is this? Who's going to take it forward? Is it going to proceed in multiple forms at once? How will a decision in one form impact another forum's decision-making process? Are all complicated issues that require thoughtful attention as tribal court works through its caseload. MOUs can be helpful, as I touched on. They can be cross-state visualization agreements, for instance, that empower law enforcement, but courts can also enter into memorandums of understanding that address their shared authority, say, over an Indian child welfare matter. And then tribes, again, have to do this all against the backdrop of limited resources. Funding can be a massive issue in Indian country, but staffing is also an issue. So, for instance, sometimes a tribe would really prefer to use tribal members as its own judges, but also has a preference to use individuals who have U.S. legal training, such as a degree from an ABA accredited law school, as their judges, and there might not be many tribal members who fit that criteria, in which case the tribe is sort of forced to decide what is more valuable to it. Is it to employ tribal members or to have that ABA law degree requirement? Next slide, please. I'll pass it back over to Lane.
Thank you. Let's talk about some of the challenges faced by the courts. Most of these are not new. These are issues which the courts have been dealing with for decades. In addition to the jurisdiction conflicts that we've been talking about, funding sources are always difficult. Consider a small jurisdiction where perhaps you managed a caseload of 20 felony cases throughout the course of the year, and that is an increase to 2,500. With your current staffing, how do you manage that? How do you manage the access to legal resources? How do you collaborate with the other agencies? You may have to provide statistical reports to the Bureau of Indian Affairs. You may have to provide reports to statewide reporting. There may be some national reporting that is required. So it is very challenging for these courts to face this quadruple change in their caseload with their current existing staffing and budgets. Next slide, please.
Now let's take a look at why these issues can be so difficult to address. Lane, I'll let you discuss some of the key factors that make addressing these challenges so demanding.
Well, most of us have a cell phone. We are accustomed to immediate information. We want to have all of the information available that we can garner on our immediate cell phones and our mobile devices. So this is what citizens expect today, regardless of whether you have a case pending in a court or whether you've been summoned for jury duty. These are some of the expectations that we as the public now have. Next slide, please. So some of the roadblocks, and we've talked about some of the difficulties with staffing and things like this, but consider things like ADA compliance. That is becoming more and more imperative with particularly with public-facing applications. We are empowering the courts with technology to obtain better statistical data. We are empowering the courts to communicate with their citizenry in an improved manner. And just keep in mind that anytime the court or a prospective juror does not have to interact with one another, that takes a little bit of pressure off of the court clerk's office or the jury administration office. But all of these technological improvements come with security issues. And that is one place where we need to pay particular attention, is to make sure that our security is substantial and it is locking down all of the resources that need to be kept confidential. Some of the cases that may come up in these courts may be sealed by the court and would not be available for public view. Next slide.
Thanks, Lane. Now, this is where technology and innovative solutions can make a significant impact. Lane, can you please discuss how leveraging modern tools designed specifically for the unique needs of tribal courts can address many of these challenges that we discussed today?
Certainly. Next slide. Thank you. Some of the important things that are helping with technology solutions are what I've already touched upon, but let's talk a little bit more about the multilingual capabilities. In your jurisdiction, if you have people that speak multiple languages, public-facing portals to communicate with the court can offer translations into those additional languages. Additionally, one of the things that I found most beneficial as a court administrator and a jury administrator was taking care of business in real time. In other words, I did not have to log all of my jury management tasks manually and then turn around and enter them into a computer for data entry. That's redundant. So it is very important that the technological solutions touch on real-time processing. And my best example of that is considering voir dire in the courtroom. During jury selection, that is a great time for the courtroom clerk to be able to record the actual impanelment results right there in real time. It doesn't have to be written down and entered later. So give staff the tools they need to do the job from their respective locations, so there's not redundant data entry and there are not a duplication of efforts. If you have encountered a 4,000% increase in your caseload, chances are your staffing resources are stretched pretty thinly, and you want to take advantage of every technological abbreviation or shortcut that you can. Next slide, please. I've mentioned the public-facing portal, and this is very important, something that we did not have many years ago when I came on as a jury administrator. It was incumbent upon the court clerk's office or the jury administration office to provide questionnaires, usually when sending out the jury summons. But now with these public-facing portals and using court technology, we can put all manner of information that used to be printed, stuffed, and mailed out to the respective court. Now we can provide all of that in one fell swoop on a public access portal. So prospective jurors can go on to this portal through a QR code or some other means of navigating to that portal. They can respond to their questionnaires. They can ask the court questions. They can upload documentation, enter in their biographical data. There's just very little limit to the information that can be exchanged between the court and the prospective jurors with a public-facing, technology-savvy portal. Next slide, please. I mentioned opening up and creating voir dire results and panel results in the courtroom. Oftentimes, court staff are tied up in the courtroom, could be all day. The last thing you want as a court administrator is for your staff to come out of court after being in there for 8 hours and have 8 hours of data entry. So give people the tools they need, the technology they need to manage the workload directly from the courtroom in real time. The last issue I have on this particular slide I'd like to draw attention to, because this is something that is becoming more and more popular. Traditionally, jurors were paid by check, 4 to 6 weeks. Your check will be in the mail. And when the check doesn't arrive in that time frame, what does that promulgate? Well, it prompts more calls to the court clerk's office or to the jury administration office. Every time a administrator or a court clerk has to take that call, that's a little bit of time out of their day. So by giving jurors the ability to pay themselves on their way out the door of the courthouse, you've just eliminated that particular issue. They can print a jury attendance letter or generate it to their personal device. They can print or manage their juror payment. So when they leave the courthouse after they're done with jury service, they are effectively completed with their service. There's very little reason for them to go back to the court clerk's office. There's also a very public PR component of that. How nice would it be for jurors to be paid immediately and not have to wait 4, 6, 8 weeks for their $12, $15, $20 check in the mail? Not to mention the added benefit for the courts is by digitizing some of this payment and making it available to jurors, that reduces the cost for the court. It is estimated that generating a check in a business costs between $4 and $20. Now, that's quite a broad range in cost, but it does incur a lot of costs to the courts for them to have to print, stuff, and mail a check that is going to go out in 4 to 6 weeks. Next slide, please. This is an example of how impanelment results may be included during jury selection at from the courtroom directly. You'll see here that you are able to enter your prospective juror results if they are selected as a juror, if they're challenged for cause, peremptorily challenged, or if they're released from service and they can go back to the jury pool, or they can also be available for future cases. It just depends on your court business processes. This would also extrapolate into the court case management realm, where there can be interfaces between the case management system and the jury management system. This facilitates that transfer of data between court case management and jury management. It can be a two-way interface whereby the court case is sent to the jury management system. The jury management system then takes care of the jury impanelment, and then results can be uploaded back into the court case system. For example, if they need to docket the results of voir dire or anything that results from the jury selection, all of that can be moved seamlessly from the court case management system into the jury management system and vice versa. Next slide, please. Juror attendance and payment. We talked a little bit about this, but it is important that to cut down on some of the traffic that goes with the clerk's office, if we provide technology where they can document their jury attendance and receive their payment, again, that is much less traffic going back and forth from the court clerk's office. It also is very helpful for the jurors because they can get paid immediately. They can provide their school or employer information on their jury attendance. And then we have it is necessary to have very strong accounting capabilities. There always have to be internal controls when there's money involved, juror payment involved. So having a robust and a complete jury attendance system that has a strong court case management system and accounting program is a business imperative. Next slide, please.
Thanks, Lane. Thanks for that deep dive into how technology can enhance court operations. I know we've discussed throughout our discussion today, but I'll give you the opportunity to share more about how technology can benefit not only the courts, but also their citizens.
Thank you. We've talked about the foot traffic going into the clerk's office. Let's talk for a moment about the accuracy from automatic payment calculations. As a jury administrator, it would often take me about 40 hours a month to pay my jurors. Once we implemented a technological solution, that went down to about an hour. That was 39 more hours in the month that I actually had to devote to more complex tasks. That was a huge time savings. Now, if you consider the original problem of courts having to do more with less, and it is even more imperative in smaller jurisdictions like perhaps a tribe might be, jury and case management, technology and efficiency is absolutely necessary. A lot of small jurisdictions will still manually process their jurors and manage their jury system this way. There may be some tribal courts that are still manually docketing cases and managing the caseload in more manual means. That is going to be a real problem when you see a 4,000% increase in your caseload. Next, please. Most everybody today has a cell phone. And as we discussed with the juror portals, this is a good example of how technology will help the citizens. They would be able to check themselves in for jury service. But I think the most important facet of this is to facilitate the communication between the citizens and the court. Oftentimes, jury trials may be continued. From the court case management side, hearings may be continued. It's imperative that the citizens be able to be notified of that in a timely manner. This is also important for types of digital courtroom processing and for virtual hearings. Consider during the pandemic, courts pivoted and really did a great job of continuing to manage their caseload in a remote manner. I think one of the most important conversations I had was with a judge who was talking about personal, sorry, Ellie. Virtual victim protective orders. When the protective orders were signed and implemented and judge was hearing testimony about the VPO, it was much less invasive to have the participants appear via virtual means. They did not have to face one another in a courtroom. The litigants did not have to take off of their work day or school all day long to attend a court hearing. He indicated that he saw his attendance rate on VPO hearings increase to nearly 90%. That was a pretty good increase. Next slide, please.
Thanks, Lane. Now I'll pass it over to Lenny to take a look at some real world examples. Lenny, I'll turn it over to you to go through some recent case studies.
So I wanted to take us through two cases and two statutes that sort of illustrate the real world way that McGirt and Caseloads are sort of playing out. And they're two cases and two statutes that I think have particular salience for tribal courts. The first case is actually one that I litigated. It's called Watkins v. Oklahoma. And it concerned who is an Indian for purposes of criminal law. Courts have generally used a two-part test for that inquiry. They ask first, does the person have Native American ancestry? That requirement comes from an old Supreme Court case issued before the Civil War that found the statute has an ancestry requirement in it. And then two, does the person have sufficient tribal connections? Now, that latter part of the test uses a series of factors, often called the St. Cloud factors. One factor is whether the person is enrolled in a tribe. Every decision I've seen treats that factor as dispositive. So if someone is racially Native American and a member of tribe, then they are an Indian for purposes of criminal law. Though courts have also said that there are other ways to demonstrate a sufficient tribal connection. And those other factors are what Oklahoma was challenging. Watkins was a case where Mr. Watkins had Native American ancestry, was not enrolled, but had strong tribal ties. The Oklahoma Court of Criminal Appeals recognized that he was an Indian for purposes of criminal law for that reason, and thus it didn't have jurisdiction. Oklahoma attempted to take the case up to the Supreme Court. They argued that a person is an Indian for purposes of criminal law only when they are enrolled in a tribe. They took issue with any other type of person being treated as Indian, but the Supreme Court denied cert. So the test that is getting used today is still that one that's two parts: ancestry, and then those factors, which can be tribal membership or can be other considerations like social and cultural ties. And that matters because the test used for tribal criminal jurisdiction, when you're trying to figure out if someone is an Indian, is the same one that the federal and state courts use. Next slide, please. The other case is one from the Oklahoma Supreme Court in Re SJW. We talked a little bit about how there is concurrent jurisdiction in Indian country. And one of the areas where there's special federal rules is child welfare. The Indian Child Welfare Act generally allows state courts to exercise jurisdiction over Indian children outside of Indian country, but provides for exclusive tribal court jurisdiction over Indian children within reservation boundaries. But in Re SJW, the Oklahoma Supreme Court construed that rule narrowly. It held that it's only when the child is a member of the tribe to whom the reservation belongs that the rule is triggered. So you have a Cherokee child within the Cherokee reservation. The Oklahoma Supreme Court recognizes exclusive tribal court jurisdiction in those circumstances. But in its view, if you have, say, a Choctaw child within the Cherokee reservation, they interpreted ICWA to allow state courts to exercise concurrent jurisdiction in that circumstance. So the tribe would still have jurisdiction, but in the Oklahoma Supreme Court's view, Oklahoma state courts can also come in as well. So that's the rule now in Oklahoma, and that interpretation may get argued in other courts around the country as well. Next slide, please. Now, at the legislative level, there are two efforts that the National Congress of American Indians has put its support behind. One is basically a Castro Huerta fix. NCAI resolution number SAC 22-39 calls for an amendment to the General Crimes Act to, in practice, overturn Castro Huerta. If the act were amended in this way, there would no longer be state criminal jurisdiction over crimes committed by non-Indians within Indian country. And then NCAI resolution number SAC-22-43 calls on Congress to enact legislation to improve public safety in Indian country, such as providing better funding, given the needs that tribes have always faced, and the tribes in Oklahoma in particular face now that the existence of the reservation boundaries has been confirmed. Next slide, please.
Thank you, Lenny, and thank you, Lane, for your valuable insights and for highlighting some of the challenges and strategies for supporting tribal justice. Today's session underscored the resilience of tribal courts as they navigate expanded caseloads and jurisdictional changes. And we hope it provided you with some actionable ideas to enhance your own court systems. If you're interested in learning more, please reach out to Lane Dunn and visit avenueinsights.com. Following today's discussion, you'll receive a copy of the presentation with links to the supporting documentation we discussed today. Thank you all for joining us, and let's continue to work together to support tribal courts and justice across communities. Thank you so much.